number 82, matter of Walsh versus New York State Comptroller. Thank you. Good afternoon, Counsel.
Good afternoon, Your Honors. May it please the Court, my name is Jonathan Edelstein. I represent Petitioner-Appellant Patricia Walsh. With the Court's permission, I would like to reserve 3 minutes for rebuttal.
You may, sir.
Thank you. Your Honors, it is the petitioner's position that the words "any act of any inmate" in Section 607C of the Retirement and Social Security Law mean any act of any inmate.
So in your view, if the inmate suffered a seizure and fell on the correction officer, that would fall within the statute and provide increased retirement benefits for the correction officers.
Well,
is that correct?
Your Honor, while I take no position on that, that's the Lorino case.
But that's something that we have to in interpreting the words of this statute, which you agree is what our job is here today, correct? We have to determine what does any mean, what does act mean, and I'm focusing on the word act for the moment.
Yes.
So if you think that an involuntary act, such as falling when you have a seizure, does or does not fall within that word, then for the purposes of the statute, then I think that makes a difference. So how do we approach this if we're not at least looking at whether there's an act of volition here?
Well, a seizure is not an act. An inmate who has a seizure does not do anything to precipitate the seizure. It's an autonomic...
Well, how do we know? How do we know that the inmate didn't, 2 minutes before that, ingest some substance voluntarily and suffer a seizure? How do we know that?
Well,
or do we have to look at that?
If there's evidence of that in the record, Your Honor, then I would submit that there is an act of an inmate.
Well, how do you know what the legislature meant by act? I mean, forget what you think it means. Was there anything in the record to indicate whether the legislature was thinking act means affirmative act, volitional act, accidental act, tripping on something, having a seizure? Anything?
Well, Your Honor, I would submit that the legislative history bespeaks an intent to provide a broad remedy to correction officers who were injured in the correctional setting as a result of things that inmates do and things that happen to them during interactions with
Before we look at legislative history, we would have to first figure out whether or not the term is ambiguous. And couldn't we start off by trying to figure out what the plain meaning of the word act is? Well, by looking in dictionaries. And dictionaries tell us that acts can be voluntary or involuntary.
Well, and certainly I would submit
Looking at
that...
that thing we all learn about called Black's Law in our first year of law school, where an act is defined as something done or performed, especially voluntarily. I don't know what especially means. Does that exclude or include involuntary acts?
Well, I would submit that where the statute contains the word any act, that is a term of general import that's meant to include all acts, that anything that could be construed as an act.
That's only begging the
if
question
that's
of
the
what
case-
is an act. And an act volitional, not volitional, affirmative, not affirmative.
Well, I mean, as His Honor said,
I mean, look, let me just get back. In this case, you must agree, given the testimony that your client provided, that the inmate was not intending to fall on top of the correction officer, correct?
Correct.
Right. So it's not like the inmate wanted to do this, sought to do this, put any motion into effect with the intent that she would land on top of the officer.
Well, the third...
And in fact, she wasn't even trying to disobey the officer, correct?
The Third Department has already held in the DeMayo case and the Traxler case.
No, but I'm talking about
that-
this case. I'm talking
Okay.
about in this case.
No, I would submit that there's no basis to limit the term act to intentional acts.
Okay, so then I'm a little unclear what your argument is with respect to what you do when you have basically a two-track disability retirement allowance system. What would be the basis by which your client, this correction officer, falls within that category of incapacitated officers that's entitled to a heightened pay?
That there was,
607-C, as opposed to the ordinary disability.
that there was an act by an inmate, namely stepping out
But
of
we're
the
back to
van,
that, okay.
that led to an
Perhaps I'm not
unintentional
being
result.
clear. So that is not defined. So we have to find what's the rationality? What is the legislature seeking to do?
Yes. Well, my opponent doesn't dispute that stepping out of the van was an act. He doesn't dispute.
I think the other side is very clear, the Controller's Office is very clear that it's not, it doesn't come within 607-C. I think that is very clear that that is their position, does not fall within the scope of this particular type of disability benefit.
Well, their position, as expressed in their brief, is that the fall is attenuated from the step, and therefore the step may have been the act, but the fall is not the act.
Well, I think that might, we can let them state their position. That may have been an alternative argument, but, you know, because act is not defined in the statute, I think that, to me, that leaves at least some room to say that there's ambiguity, which then causes us to look to, and in line with what Judge Rivera said, what was intended to distinguish this level of benefit from an ordinary disability retirement benefit. And I think it's pretty clear to me that the legislature was referring to the type of danger that is unique to the prison or the inmate officer relationship. And I have trouble seeing how falling, stumbling, whether she took a step or a step and a half or didn't, intentionally or unintentionally, how that would fall within that legislative intent.
Well, I would first of all refer to Senator Libel's memorandum, which specifically mentions transporting inmates as one of the situations that can cause these dangers that the
The problem
statute
with
is intended
those,
to
that kind of
remedy.
history generally, but that type of letter is, to me, that means, sure, as you're transporting prisoners, there may be an opportunity for violence or escape or some type of inherent risk in the prison system, right, with having people incarcerated. What I'm trying to get a handle on here is how, going to the purpose of this, how does this type of disability with this type of benefit fit within the overall scheme of what would be available to someone in your client's position, right, in this position? So there is a disability benefit, right, that's available outside of this statute.
For those with a certain amount of time in service, which would mean that if somebody were injured this way who didn't have the time in service that Ms. Walsh had, they would be out of luck.
Right, but for her, with her time in service, she would qualify for another type of disability benefit?
I believe so, although the record really doesn't shed much light on that.
And would that, if a person were qualified for that, that would not depend on whether or not it occurred even in the line of duty, is that correct?
I believe that outside a heart bill situation, that it does require that the disability occur in the line of duty.
Okay.
Again, this is not something that the record really speaks to. It's something I could research if the court wants me to.
But I want to understand if what you're advocating would lead to us holding that all injuries that are caused by some contact with an inmate would somehow qualify for this POD benefit.
They would not.
And if not, what's the limiting principle?
Well, the limiting principle is provided by the words of the statute, natural and proximate. that
So
the cases...
So the acts are always going to be, satisfied. That part of the statute is going to always be satisfied once you have the inmate and the whatever happened together.
Once you have the inmate doing something, and when the inmate doing something causes injury to the officer, yes, I would...
Isn't that the same as the direct interaction? So it seems to me that there are a couple of, there's the direct interaction and then there's the act. It seems to me those are two different things.
Well, direct interaction is not part of the statute. Direct interaction is part of the gloss that the Third Department has put on it to identify the word act.
That's really the issue here, isn't it? Because I think Judge Stein's right, that the proximate result of the action, that's, I think, an easier thing, more measured, and it's also not measured by this statute. What this statute, what we have to decide on is whether the plain language means any act or the plain language means any particular type of act. And then there's a series of cases that define those types of acts.
Well, Your Honor, the statute does include the words natural and proximate. That's not a judicial gloss.
Hold on.
That's plain language.
But it includes it in one clause and not the other, right? There's an or in between them.
Yes, by or as the natural...
No, I understand that the statute says that, and Judge Wilson's right, there is an or, but I understand the statute says that. My question to you, though, is in terms of what's really at stake here is what any act means. Would
That
you
is
agree with
correct,
that?
Judge.
Okay. All right.
Thank you, counsel.
Thank you.
Counsel?
Judge Stein, unlike my opponent, I do have a position on the seizure hypothetical. And in that scenario, if the inmate has a seizure and falls on the officer, there has not been an act. The word act is the critical.
What if they have a seizure and they can't control their movements and they hit the officer with their arm? Different answer?
No, it would be the same answer. There's a lack of a volitional act. The term act is ambiguous, and I have before me this.
So act means what? I intend something? I intend to move my body in a particular way? What is act?
It can mean what we say it means, which is something done or performed, or an occurrence resulting from a person exerting their will in the external world. That's the volitional sense. It admittedly can be broader and include involuntary or non-volitional acts.
Here's the
That's why we're here.
So that's why we're here. And if the legislature wanted to limit it to volitional, why couldn't they just assert the word volitional in front of the word act, or the word intentional, or whatever limiting language you can think of?
They could have done that. We wouldn't be here if they had, but if you look to the legislative history, you see the types of acts that the legislature was concerned
But in
about.
the absence, and we don't go to legislative history, if I understand Judge Feynman's point, unless there's some ambiguity in the present language. And when I look at this case, Mr. Palladino, what I wonder is the ambiguity in our analysis and the analysis of this issue engendered by the jurisprudence around the case rather than the language in the statute itself. And let me tell you what I mean. Then you can respond to it. I went through all the cases and I listed the various words that were used to describe the act. And I came up with 8 so far, and I'll give you a listing of the words that have described these particular acts in the different cases. Intentional, overt, affirmative, voluntary, disobedient, unruly, antisocial, 7. So I came up with 7 so far that in various cases that describe the act, and almost all the words are words of limitation on the act itself. And it seems to me, going back to Judge Feynman's point, that if they wanted to do that, then they do that. So that's usually what they do when they know how to write these laws. But this is an area of the law that's well poured over. It's parsed word by word by both the legislature and the legal profession. So it seems that they would have done that if they wanted to do this. So if we stick with the plain language, I think we're logically almost stuck with a definition of act. I agree with all my colleagues that that's right, but a definition of act that doesn't have all these limiting words that have been put on by our jurisprudence.
The word act by itself is ambiguous. If I say that an inmate collapsed and fell off the back of the van, you wouldn't say to yourself, well, he committed an act. No, you would say something happened to the inmate. You could also say, though, the inmate did something, he collapsed. That's why it is by itself on its face, an ambiguous term. If you go, I have before me the Black's Law Dictionary definition that Judge Feynman referred to, and in it, it refers to the fact that the term is of ambiguous import, being used in various senses.
Can I
So
just
if
walk
you, I'm sorry.
No, go ahead.
So if the analysis is that you can't get to legislative history unless there's facial ambiguity, there is.
I just want to ask you about the structure of the words in the statute. So it looks to me that you have to read it as if there's a comma there that isn't in the words. And let me start with that. Then we have an or, right? We have by, and then or the natural and proximate result of. And I assume the by has to pick up any act. Is that right?
That's how I would read it. In other words,
I don't see this. Otherwise, what can the by attach to?
right, I mean, if the
Okay.
inmate obviously punches the officer, that is a disabling act by the inmate.
Stick with me for a minute then. So there are then two paths, it seems to me, in the statute. One is an injury sustained in the performance of discharge of the duties by any act of an inmate, or as the natural and proximate result of any act of an inmate. So how are those two different? What is the legislature trying to capture in one and not the other, and vice versa?
Well, the by would encompass the situation where the inmate slugs the officer. That's the direct act by the inmate. Let's say there's a struggle going on between two inmates, and the officer sees the struggle, starts to get involved in the struggle, and throws out his back. That would be not an act by an inmate, but certainly as the natural and proximate result of an act of an inmate. But all the senses that Judge Fahey listed in the case law are all types of volitional acts. I think it's true, as Judge Stein noted, that there was a certain type of special risk unique to the correctional environment that was the justification for this statute.
But in the by clause, there's an absence of a proximate cause requirement.
Well, if you have the by, I think you necessarily have the if I punch you, I think that and that disables you.
But there's a difference between but-for causation and proximate, no?
But I think this was intended to be written such that proximate cause is modifying both instances,
Well,
both the
except that
by.
it's not written that way, is it?
Yes, it's not an artfully drafted statute. I will grant you that.
So, looking at 607 for a moment, not just the C sub A, but also C sub B, which is the section that deals with people who get these communicable diseases, right? So that uses the word an act of any inmate also. And yet, you would agree that that section is not requiring any volitional act, right?
Well, I think it was.
I mean, it's a presumption statute, I get that. So how do we reconcile that, these two?
Well, I think B
sections.
is addressing a related problem. Prisons are not only violent and dangerous places, they are infected with lots of diseases. And the legislature recognized that an officer, by being in a prison environment, just by breathing the air, can acquire
Tuberculosis or whatever. Yeah, I mean.
the hepatitis. You can get that in a variety of ways. HIV, actually, they do have the reference back to an act of an inmate. But I think the reason for the different treatment there is that those are slightly different problems that the legislature was confronting at the same time. But under no...
Does the use of the word an act help us figure out what an act means in the one that we're dealing with, sub A?
I'm not
Or
sure
it's not informative?
Well, I think that if you, again, recognize that it's ambiguous on its face, it certainly is not reasonably read to include non-volitional acts. There's no way you can look at what was motivating the legislature. They were concerned about violence and altercations. Admittedly, they draft a statute that goes beyond that. I will agree with my opponent that what they wrote would cover negligent acts of inmates, but all of those are volitional acts. The coverage in that instance would be going beyond the specific problem identified by the legislature. But what we're concerned about is don't take the additional step.
Okay, so this is why I don't understand your point that this includes involuntary acts. Like, I don't read act to mean an involuntary movement.
Oh, I don't read it that way either.
Sorry,
What
then I misunderstood you. I
No.
thought before you said it includes involuntary acts.
No, what I meant to say was that the term act is ambiguous. It can mean voluntary acts, or it can mean voluntary or involuntary.
No, but that's, I'm sorry.
Here's
I
the
just want to
Go
clarify
ahead,
that.
Judge.
Why is it ambiguous? Where can you track back that the word act includes involuntariness?
Well, if you go to Black's Law Dictionary, some of the senses.
Okay, then we
But
just
again-
disagree. I don't read it that way.
All
But
right.
let me ask you a different kind of question. Oh, well, actually, Judge Fahey had a question. Then I'll-
Yeah, I just want to stay on this point. It's not ambiguous. The way I see it is it's all-encompassing, and it includes both voluntary and involuntary acts. The phrases that we, all of us in our discussion are referring to, are phrases that limit the nature of what an act is. It's unruly, it's disruptive, it's voluntary, it's involuntary. Those are all slices of what an act is, but the phrase "any act" encompasses all those phrases. So that's, I guess, where I'm disagreeing. I'm not getting your argument that it's ambiguous, because it seems to me that this legislation may have been written too broadly. I can understand that, but that's not the same as saying it's ambiguous.
The argument, I think that's petitioner's argument, kind of begs the question. If act was intended to embrace simply volitional acts, which I think is the ordinary understanding of the term when you say someone acted, someone did something, as opposed to something happened to them, adding the word "any" simply means any volitional act is what it means. And it's clear from the legislative history that this statute was intended to confer the same coverage as the statute that governed state correctional officers, which simply uses the term "an act of an inmate" as opposed to "any act of any inmate." And I think when you consider that, "any" and are really synonymous in that context, and are not intended to expand act beyond the volitional sense. It's simply saying any volitional act. So if the inmate in a work crew intentionally, lifts his arm and strikes an officer, even though he did not intend to strike the officer, that was a volitional act, and that will suffice to satisfy the act of an inmate requirement.
So let me ask you about all these other terms that Judge Fahey mentioned. Are they all included within volitional?
Yes, unless I heard him incorrectly.
It's in your view, the third department isn't saying that these are each and every one of them are different types of acts or different limitations on what an act is. It's one limitation, it's volitional. That's what you're saying, affirmative or volitional.
Correct. We are not saying, despite what the petitioner is arguing, that there has to be a disobedient act. It just has to be volitional, and then it has to be the proximate cause. So here, even if you view this involuntary
And it
collapse...
doesn't have to be antisocial.
Correct.
And it doesn't have to, be intentional.
Correct. But even if somehow collapsing and falling off the back of a van somehow qualifies as an act, where the petitioner fails is on the proximate cause end, because the hearing officer found that the injury was attributable.
Now, I think in an effort, now I'm losing the limiting principle, because now you've really kind of said it is almost anything that an inmate does, and I didn't think that's really where you started. So, but I wanted to ask a different kind of question, which is going back to some of the questions that were asked of Walsh's counsel. If you could please help me understand this two-track disability process, and where someone like Walsh, if she doesn't have 10 years in, would she be eligible for ordinary disability benefits under this event? Would it fall under B3? Is it an accident? Where does this fall?
No.
Or end up, I shouldn't say
It is
fall.
true that what are available to corrections officers, other than the sort of service retirement,
Yes.
are ordinary disability, which you at least have to have 10 years. If you do, it doesn't matter whether you are disabled on the job or
Off the job, right?
off the
Yeah,
job.
yeah.
And they have this performance of duty disability retirement that gets the most generous possible benefit. The alleged inequity was between correctional officers and police officers and firemen, and they have ordinary. They have performance of duty, but if it's a performance of duty, they only get 50% of their final average salary, and they have accidental, which is a very technical term of art that has caused a lot of controversy. What they gave to the correctional officers was a performance of duty limited by an act of an inmate, which we say has to be volitional. But if they get it, they get the highest possible retirement benefit of 75%. But someone in the situation that Your Honor identified, who unfortunately doesn't have the 10 years, is out of luck. That is an unfortunate consequence. This petitioner is getting ordinary disability retirement
So then
benefits.
605B3, that speaks to accidents, would not, unless you have 10 years, well, actually, it doesn't apply to the 10 years, wouldn't apply to an inmate's misstep?
I'm sorry, the correctional officers do not have accidental disability retirement benefits. They have this benefit, which if they qualify for it, they get an amount equal to the accidental benefits, which is 75%. And that's one of the reasons why there has to be some limiting principle, that you're giving the most generous possible benefit, and under the statutory scheme, the higher the benefit, the harder it is to get.
Under that accidental disability benefit, which she does not qualify for, what's the percentage you get for that?
75%
So
of your
why
fund
would it be more limited than that if it's the same percentage? Like, why would you need is the limiting percentage in the accidental disability benefit, not this one, the other statute, is that limited in some way?
Well, an accidental benefit, if this was a police officer, if this happened to a police
Right.
officer, that person presumably would not qualify because this type of incident is a foreseeable risk of their job duties.
But they still get some type of accident,
They-
line of duty, or they get accidental benefits, or there's some type of thing. But I thought you were saying that this statute makes up for the fact in some way that these types of employees don't qualify for this accidental benefit statute, and therefore we need a limiting principle.
What I was trying to say was, before this statute existed, all the correction officers had,
Was
unlike the
ordinary
police officers, was
disability.
ordinary. But what they wound up giving them, they didn't wind up giving them exactly what the police and firemen get, which is disability 50%, accidental 75%. Instead, they gave them this performance of duty so long as there is an act of an inmate, and if you meet that requirement, you get the 75%. And it's because it's so generous that we're saying there has to be a limiting principle.
I'm sorry, so to whom does 605B3 apply? It doesn't apply to corrections officers?
605B.
Just to be clear.
605B3, I think that you're talking about the ordinary. 605.
Yes, it is ordinary.
Is ordinary for.
Accident, as long as you're not negligent, the officer themselves?
The ordinary is just you get disabled.
Right. Less than
And-
10 years as a result
you-
of an accident, no?
You have to have at least 10 years of service
For the ordinary?
for the ordinary, and then you get disabled, and it doesn't matter how or where that occurs. You're
But I thought
off-duty.
605B3 said if you don't have 10 years in, you could still get that ordinary disability for an accident. Did I misread 605B3?
I don't have 605, I don't have that section in front of me, Your Honor, and I could
Well,
confess I don't know what you're referring
it's
to.
mentioned in footnote 1 of page 3 of the corrected brief. For the respondents, it says, if the member was incapacitated as a result of an accident sustained in service, 10-year service requirement does not apply.
Yes, so that would be, I guess that would be an alternative instance in which you can get the ordinary.
Okay.
Okay.
But Walsh would not fit in under this? Put aside the 10 years service for the moment, because this would not be considered an accident? That's what I'm trying to clarify.
I don't think this would constitute an accident because it's a risk, a foreseeable risk of doing your job.
Of doing the job.
Right.
Because it's not an unforeseeable
Right.
event.
Correct.
Foreseeable that during transport, you might get injured,
I think that would be.
not by a volitional act in the sense
Right.
of they're trying to escape, as Judge Garcia mentioned, or actually get into a fight, but they slip and fall, the misstep.
Yes, Your Honor.
Thank you, Mr. Palladino.
Thank you.
Counsel?
Briefly, Your Honor, I would like to pick up on the distinction between by and natural and proximate result. And I would submit that's very relevant here, that the by is where there's nothing between the act and the injury. The inmate slugs the officer goes down.
Well, look, it's poorly
Nat-
drafted, and one could say poorly drafted includes using by to mean by the natural and proximate result. The by or as is referring still to the natural result, because otherwise you're going to have a comma after the natural result. So you've got poor drafting, or
but-
potentially challenging drafting.
Poor drafting or no, a natural and proximate result doesn't have to be a one-step result. It could be, where, as my opponent says, an inmate is exerting their will on the external world, but there doesn't end the way they willed it. There is an accident. There's a slip between the cup and the lip, or as here, between the van and the yard. The inmate here was exerting her will in the external world. She got up and she made 1.5 steps. The natural and proximate result of trying to take 1.5 steps off a steep, highly placed van while you're drunk or high is that you might fall. So I would submit that there is no attenuation here between the act, which my opponent agrees is an act, of taking these steps and of the fall. That, that's like saying that there's...
When there's movement, the question is whether or not it means act within what the legislature wanted covered under 607-C. That's the question.
That is the question, but I don't think my opponent disputes. And in fact, I think in front of this court, he just said that he didn't dispute that taking a step would be a volitional act. In his brief, he certainly agrees that taking a step is a volitional act. So where a step is taken, where there's this volitional act, but as
So
a natural...
If we disagree with you about the step, does that change the analysis here about the step before the stumble or the fall?
You mean if the court were to find that the step was not volitional?
If the constellation of what happened here did not constitute a volitional act, yes, of the inmate. Well, I guess that's answering the question. That wasn't really what I was asking. You seem to be relying on the fact that this 1 or 1.5 steps was volitional. Does your argument depend on that, on those 1.5 steps? Or what if she stood up? Is that enough? Is that a volitional, that's a volitional act, and then just keeled right over?
Standing up is a volitional act, Your Honor.
Okay.
And there was
How
also
about
a volitional
this?
act.
How about this? I go out, I go to a neighborhood bar, I drink for 2 hours, I get in my car, I'm drunk, I drive for 3 blocks, I'm still intoxicated, I swerve, hit another car coming in the other direction. Was my drinking that led to the DWI charge and the accident a volitional act?
Yeah, it was absolutely a volitional act.
And what if somebody put a pill
wanted to make
in my
sure.
iced tea, and I had no idea, and I was apparently intoxicated or drugged? Is that a volitional act?
Well, it depends. If somebody puts a pill in your tea and you feel woozy, but you nevertheless go out and drive, yes, that's a volitional act.
Well, what if this particular person had something slipped in her drink? So she didn't get in a car and drive. She was brought to court, or she was being moved. She didn't ask to be moved. She didn't ask to be put in that van. She was put in that van. So I guess my point is that there's nothing in this record as to how she got to be in that state that she was in. So how do we say that it was that in and of itself was volitional?
Well, Judge, because the involuntary intoxication is very much the exception. When somebody is intoxicated, 999 times out of 1,000, it's the result of voluntary intoxication. And if there was evidence in this record that something was put in her drink, then maybe it's a different story. But there certainly is nothing from which it could be inferred that her intoxication was anything other than what intoxication ordinarily is.
But does it matter whether she is dragged into the van or dragged out of the van by the police officers, the corrections officers, versus the correction officers tells her, stand up, we arrived back at the jail?
Well, it depends on why she was being dragged out, Your Honor. For instance, if she was being dragged out because she refused to get up and leave, then there would be the volitional act of her refusing to get up and leave. Here, we have the volitional act of getting up and leaving. Either way, there has been an act that has been performed, and there is a natural and proximate result to that act, which is, and I would point out also that the correctional setting accentuates the risk, because you have here someone who is handcuffed, not leg shackled, but handcuffed, which is going to impair movement. Sometimes the inmates are shackled. You have this van that is specially designed for the correctional setting, and it's a very steep step off of it, 2 steps off of it. And I think the risk is accentuated by the fact that in this record, 3 other officers got hurt in the exact same van, in the exact same way. That one of the things that happens when inmates perform the volitional act of stepping out of this van is that they may fall. It's happened 3 other times. 2 of those officers, by the way, got active in inmate benefits. And I would finally
So
just...
the question is whether or not the legislature, having 2 different disability retirement allowances available, would have provided what they call the generous allowance under the circumstances where the inmate steps.
Well,
And as I think Ms. Walsh described it, takes a header and
yes.
falls on top of her.
Well, look
Versus
at the...
where she's fighting with her and trying to either escape or is violent
Well-
directly, right, towards the inmate.
But taking the header is a result of her antisocial nature in and of itself, for getting drunk and high while a prisoner. And I would... there's legislative history other than the part that the Kaler Court focused on. I mean, the very same governor's memo talks about a member of the service sustaining a debilitating injury while executing his or her duties. We must provide them with the means to take care of themselves and family. Senator Leibel is not only talking about violence. It says violence, assault, transmissible disease, and other life-threatening situations.
Counsel, it seems to me the problem where we seem to be struggling with this case is there must be some common sense definition of act that would exclude the case, and I think this is near a real case in the third, where you're carrying an inmate on a stretcher, they drop one end of it, it lands on a guard, and the guard is injured. Versus what I think would be a seizure where in the course of that seizure an inmate strikes a guard versus an inmate faints, they go to catch the inmate, and there's an injury. And this, to me, seems kind of arguably somewhere in between, if you can find that common sense definition, and then would become an issue of standard of review. So what would the common sense definition of act be that would divide the universe of these cases that way? Because, mopping the floor, and that we can say is a causation issue, but mopping, it's been determined to be sometimes an act problem. Mopping the floor and someone slips an hour later versus, striking a guard. So what is the common sense definition of act that you could give me that would satisfy that problem?
Well, I would say that an act is a bodily movement by an inmate that is not an autonomic body process. That the inmate moves a muscle, says a word, does something.
So a bodily movement caused by an inmate?
Bodily movement caused by an inmate, yes, Your Honor. That's what I would submit as
Although
an act.
just a moment ago you said someone refusing to make a bodily movement would be an act.
Okay, actually, then I would amend my answer. I would include words spoken by an inmate that result in some sort of action being taken by the correction officers.
Thank you, counsel.
Yes.